Hey Olivia, my name is Sam McMillan and I'm going to be walking you through your situation today and hopefully answering all questions that you have regarding your situation. So it seems that you've come to me asking whether you're legally obligated or binded by contract to pay for some mugs that you accidentally broke in a store because you knocked them over with your backpack and you saw a sign that said, "You break it, you buy it." So we're going to go through the situation and we're going to look at what happened, the laws of a contract, and what your next step should be given the situation. Okay, Olivia, so first we're going to break down the situation based on what you've told me. As a recap, you were shopping in downtown Anderson wearing a backpack when you turned and suddenly hit some mugs, 10 to be exact, knocking them off the shelf and breaking all of them. The store owner claimed this caused $200 in damages and pointed at the posted sign, "You break it, you buy it," claiming you were contractually obligated to pay for them. I see that your key concern here is that whether the sign really creates a legally binding obligation or a contract for you. Okay, so let's quickly run through what a contract really is. See, contract law is all about relationships and promises. Its main goal is to make sure people keep their promises. Most importantly, contract law is based on the objective theory of contracts, meaning there must be clear intention to form an agreement. You cannot actually enter into a contract without knowing that one exists. See, a sign by itself does not automatically create legal duties unless it meets the requirements of a contract. Okay, so now we'll cover the four main elements to a legal contract. See, for a contract to be valid, these four elements must exist. First is the agreement. This is where there's a valid offer from one party as well as a valid acceptance from another. Second is consideration. This means each party must exchange something of value for the contract to be legally binding. Third is capacity. Both parties must legally be capable of contracting. See, this could be restricted because of mental issues, age, or other factors. Fourth is legality. The purpose of the agreement has to be lawful for it to be a legal obligation. If any of these are missing, the contract is either void or unenforceable. Okay, so now we can quickly go over contract classifications and why certain contracts are different than others. So first, there's an express versus implied contracts. This is where terms are stated versus where terms arise from the conduct or situation of the contract. There's also formal versus informal. Formal follow a certain format, but most contracts are seemingly informal and do not. There's also bilateral and unilateral contracts. Bilateral is where there's a promise for a promise, unilateral being a promise for an act. See, in your case, the store might argue it's an implied unilateral contract, but without clear acceptance or an agreement, that argument becomes weak. Now that we understand the main elements needed for a contract to be legally binding, let's evaluate those elements in your situation. So for the agreement part, including the offer and acceptance, the store is not actually making an offer, it's just a store sign. This is more like a policy than a legal offer. And for acceptance, you never agreed to anything. Simply shopping around is not legal acceptance. So this is void in this part. Consideration. So you didn't actually exchange anything of value at the time, so this would also be incomplete in the contract. Going on to capacity and legality would both seemingly be complete here because you are both legally able to contract as far as we know in the situation, and there's nothing illegal occurring within the contract. However, the first two elements of the contract are missing, which means this does not create a binding contract. Okay, so now that we understand the essential elements needed for a contract, as well as how they apply to your situation, let's quickly look over contract enforceability. So a contract is enforceable if all of the four elements exist, and if one party doesn't hold up their end of the contract, they can quickly be sued for breach. A contract becomes unenforceable if all elements appear to be present, but they can't be legally performed. A contract is voidable if all four elements appear to be present, but one of the parties has a lawful option to set it aside. Finally, and most importantly in your case, a contract is void if one of the four essential elements is missing from the contract. See here, the sign-based agreement is void because the key elements, agreement and consideration, are missing. Okay, so now knowing all of this, where does that leave you? It's become pretty clear that you're not automatically liable under contract law in this situation. See, the store could try a negligence claim saying you were careless with your backpack, but you could quickly argue the shelves were crowded or fragile items were placed unsafely. This would leave the store having some responsibility. My advice for this situation would be considering a small payment as goodwill, but understanding that you're not legally obligated or bound just because of the sign. If the store insists that you are, they'd have to pursue this in small claims courts in pursuit of negligence, but they probably won't go about this due to time and expenses. So in short, you're not contractually obligated. So whether you compromise or stand firm is up to you, but legally the store owner's claim is weak.